But anyway, I think this issue of scaling up is one that we really, really have to pay attention to. And I don't see any way to do that without enlisting the Department of Justice as an ally. And as a staunch ally, and perhaps as a leader in this effort. And that may be a bit of a pipe dream, but I think it's possible.
Great, thank you, Margaret. And JaneAnne, welcome to the panel. I hope your trial is going well. I'd like to pose that same question to you in terms of what institutions do you feel are the biggest impediments to pardon reform, and what institutions or programs or projects do you see as the best solutions in terms of pardon reform?
Well, we have an interesting situation here in Minnesota that there ended up being a really large coalition of groups supporting second look for juveniles who were serving life sentences and would get a second look after 15 years. And in fact, the County Attorneys Association supported that bill. So one would have thought that that would do well in the legislature, given the fact that the prosecutors were on board. And unfortunately, the Republican legislature here decided, oh my goodness, now even the prosecutors are getting soft on crime. So we have to be the ones to get tough. So, your institutions can be a particularly I don't want to necessarily say it's partisan, but it could be, it's a tough law and order driven legislature can be an impediment. And certainly prosecutors have been an impediment to this kind of process before, except I think they're breaking down on it and beginning to see that it's actually doable. It can be done in a more systematic way, and it can still be done with individualized justice. And so it's quite interesting what's happening with the individuals at home on home confinement. My understanding is that the BOP has identified a specific number of individuals, presumably hundreds, if not thousands on that list, who are meeting some criteria we don't exactly know. There's some announcement they have to have 4 years left, or whatever, but and they're drug cases. But then there's going to be some other process. I've had clients who've been told you must put in your clemency petition now because they weren't actually people who had a pending clemency petition. We're trying to supplement the clemency petitions of other individuals who were identified and told that they were identified. So there's going to be an additional individualized process will occur for those. And so there's going to be a scaling up. That's a pretty big scaling up. But at the same time, there are a lot of people who won't make it. I mean, we've got non-drug cases that aren't going to make it. I've got people who have more than 4 years left on their sentence. And I've got people who are sitting in custody right now, waiting for their CARES Act release, who should be out, but for the ability to set up some home confinement. And so it's going to require the kind of work that occurred with Drugs -2, for example, to create those committees and coalitions to really scale upwards, given the number of individuals that are affected by this.
Great, thank you so much. And now I'd like to start taking some questions from the audience, and we'll flip back and forth between that and direct questions to the panel. But Judge Martin, if I could direct this to you, this comes from someone who has a loved one who's incarcerated, who asks why there's such a difference circuit-wise among circuits as to who's getting compassionate release granted because of the First Step Act in 924C cases. So I guess the essential question is, why is there such a difference based on the circuit that these are being pursued in?
It's a great question, and I wish I could give you a good answer for it. I had a law clerk one time who was here with me in the 11th Circuit. And it was very common here for prosecutors to stack these gun charges. Kind of a common crime. If somebody's going to go into a 7-Eleven and steal the money in the cash register, a lot of times what they would do is just go down the interstate and stop at one, and then the next exit and the next exit. And so what the prosecutors would do, in most cases, nobody was hurt, very little money was taken. And but the prosecutor, the common practice was for every one of those robberies, the prosecutor would add another gun charge, which would add another 25 years to the sentence. And so you would have these sentences kind of routinely imposed of 800 months, 900 months, 1,000 months, whatever. And then this young law clerk of mine went and clerked for Patty Saris in Massachusetts. And he called me and he said, Judge, they don't impose, they never stack 924C charges. So, you know, there is discretion in the prosecutors about how to charge these cases. That has a big effect. And, you know, oftentimes, you know, the judges are just a bystander in that practice. And I don't know, Carter, if I have a minute to talk about, you know, Margaret's mention of how my circuit's kind of out of step with the other circuits on this. I call it compassionate release. Margaret objects to that term, understandably. And I can talk about it because that's another way in which, you know, people who were sentenced in Florida, Georgia, and Alabama are just treated differently than people with identical records in other part of the country.
Sure.
I don't. Do you have a minute for that?
Yeah, please.
So this is a case that's in line with what Judge Gleeson is doing in his Holloway project. This is a man named Thomas Bryant. He also has a great lawyer, Sean Hopwood. Mr. Bryant was a police officer. He engaged in some fraud that I think over the period of time he engaged in, he netted maybe $25,000 or somewhere in that neighborhood. I can give you the site. His case is at 996 F3rd 1243. It was decided by my court in 2021. You know, the punchline is I dissented. So Mr. Bryant was sentenced to 49 years. When his case came to our court, he had already served 22 years. He had an exemplary record in prison, and he moved for so-called compassionate release under the First Step Act, you know, based on a number of things, one of which was exactly the argument that Judge Gleeson is making in his Holloway project. Look, it would not be legal to sentence me to 49 years today, you know, because the First Step Act no longer allows the stacking of this 20, at the time it was 20 years for him, but, and, you know, every other circuit that's, you know, addressed these compassionate release cases. In our case, the district court denied compassionate release. And the rationale was that the sentencing guidelines don't allow release for this reason. And that all goes to, I mean, the whole reason for the First Step Act, or one of the reasons for the First Step Act, was that, you know, previously 18 United States Code 3582C1A only allowed the director of the Bureau of Prisons to ask for this compassionate release, and the Bureau of Prisons just wasn't doing it. There's some statistic that, you know, 13% of the people who asked the director of the Bureau of Prisons for this type of relief died before they ever got any of this. So, you know, Congress recognized this problem. They wanted to allow, you know, people in prison to ask on their own after some process, go to court and ask for this type of release. And, you know, part of the issue in our case is that, you know, the First Step Act was passed in December of 2018, and the United States Sentencing Commission hasn't had a quorum to act since the First Step Act was enacted. So the Sentencing Commission has never had an opportunity to kind of fill out the process for compassionate release. by changing the sentencing guidelines. But the two judges in the majority on the panel that I said that this was an impediment unless a prisoner could show basically that the director of the Bureau of Prisons had said theirs was an extraordinary and compelling case which demanded compassionate release. They just couldn't get it. And I as I so often do, I dissented, but that's currently the law in the 11th Circuit. And so, to your questioner, that's another example of, how people in Georgia, Florida, and Alabama are treated more harshly than people in the identical situation elsewhere. And the only other thing I have to say about that is I'm so sorry about it. I don't think it should be that way. And it must be very difficult to understand.
Judge Gleeson, I saw you came off mute. Did you want to add to that?
Oh, no, I did that purely by accident, Carter.
Okay. Well, actually, perfect timing, because my next question is to you. From the audience, someone has asked about your comments about 924C being imposed in a racially discriminatory manner by prosecutors. And the question goes to what the evidence is of that. What is it evidence? Is it statistical? Is it based on a demonstration of intentional bias? Is it unconscious bias that is being exercised, or do we know? But that's the essential question.
Yeah, sure. There are 3 reports. It's the commission's data, and I'm going to get to how this plays out in court, which is a remarkable thing in a minute. But the commission's data in the 15-year report in 2004, in that big fat mandatory minimum report in 2011, and then again in March of 2018, the commission issued reports regarding mandatory minimums generally in those first 2 instances, and then gun offense mandatory minimums in March 2018. All 3 times it said that prosecutors that the Black men were a certain portion of the eligible caseload, that is for stacked 924Cs, but a much higher proportion, and the numbers change from each iteration, a much higher proportion of those who actually were required to face them. And in fact, in 2011, called upon Congress to do something about it, to make it a true recidivist statute, to lower the sentences, allow judges to run them concurrently instead of consecutively. So it's indisputable. It's not my data, it's the commission's data, never disputed by DOJ, that prosecutors, when left to the decision whether to invoke those harsh mandatory minimums, did so in a way that was racially disproportionate to the disadvantage of Black men. Here's the amazing thing. And, I was a prosecutor. I have no doubt the office I was in did the same thing. And one would like to think that implicit bias kind of being baked into our culture, implicit bias is the reason for it and not overt intentional racial discrimination, although you can't discount that too. But the remarkable thing I discovered is this. You would think that would be an extraordinary and compelling reason to reduce these sentences, be the undisputed visitation of them on Black men. But every time I argued that in court, I ended up ceasing using that in court as an argument, because I had one judge say to me, "Are you calling this prosecutor next to you a racist?" I had another judge say, "Well, the U.S. attorney at the time was African-American, so how could this be?" I had one prosecutor suggest to the court that I should be referred to the disciplinary committee because I was accusing the prosecutor of racism. And look, I'm not saying anything that many of us don't know. We have a very difficult time discussing racial inequities baked into the criminal justice system. And I'll finish this point by saying as follows. We've won 30 cases. In all of them, judges have written. In not a single one has a judge mentioned the racially disparate invocation of 924C. So even the judges who agree with us, even the judges who grant us the relief, don't mention it. It's kind of a striking thing, right? It's a window into, it's like one discrete window into how dysfunctional we are when it comes to dealing with racial inequities. This one, undisputed, documented by the commission's data in our system.
Yeah, I would add to what you just said, Judge, in terms of desire to shift blame for outcomes. I experienced that firsthand as a prosecutor when there was another sentencing commission report that didn't focus on 924Cs, but focused on disparate sentencing based on race, dependent on the length of sentence. So it didn't show much difference if folks were charged with the same crime with the same criminal history in the 6 months to a year range. But when you got out to 10, 15, 20 years, it started to get worse in terms of folks of color being given heavier sentences. And when we raised it with prosecutors, prosecutors said it was the judge's fault. And when we raised it with judges said it was the prosecutor's fault.
Right.
So everybody's kind of pointing in different directions in terms of how to explain it. There's a question to everybody from the audience, whether anyone thinks that federal parole has a chance of coming back, given COVID, given overcrowding, given increased awareness of criminal justice reform. Do any of you think that federal parole has a shot?
I'll say quickly, I'm not in favor of that. I believe in the transparency that the sentencing reform movement brought in to take away the opacity of those parole decisions. Those second looks belong back in the courtrooms, if not in the courtroom of the judge who imposed sentence, because many judges move on. But the transparency and the requirement of explanation of reasons associated with federal sentencing today suggests to me that's where it belongs, not in a parole commission, but back in the courtrooms.
Well, I would say that might be right, but to me, that's not the critical question. We have a system where every correction system I'm aware of has a sort of classification and evaluation function. They know what is going on with the inmates in terms of their education and in terms of their disciplinary violations and all that. In California, we kind of brought parole back a little bit in the sense of enhanced good time credits. And good time credits, I think, are consistent with the transparency that Judge Gleeson wants, because it's the system, right? Everybody knows you get a sentence of X, but you might get some good time credits, so it is consistent with the idea of truth in sentencing. But the thing about parole is that we already have this evaluation of every inmate going on already. And even if sort of the recommendation or the spreadsheet of how people were doing did go back to the courts for the actual decision on release, I don't want to leave it to individual initiative of defense lawyers or of individuals and families to file a case, because that's not going to get a sufficiently high percentage of the people who deserve it.
I'll just add a note to that. When the American Law Institute was developing its model penal code provisions 10 years ago, or almost 10 years ago, they developed what they called a second look provision. And that provision has now been taken by the National Association of Criminal Defense Lawyers. JaneAnne has been a leader in that effort and elaborated. And it does leave the decision in the courts. It doesn't necessarily, or it doesn't recommend that these cases be brought back to individual courtrooms, but it proposes this is the ALI proposal, a commission of perhaps retired judges that would be the ones that would make these decisions, and that cases would be brought back automatically after a certain period of time. The ALI proposal was 15 years. That seems an awful long time to me. But that notion of, so I don't think the parole as we used to know it will be brought back. What I hope will be that there will be a parole-like function that is administered by the courts in a regular way, in a transparent way, and in a fairly automatic way. And hopefully going forward, we won't be imposing these draconian sentences anymore so that this will be eventually a kind of a disappearing problem. JaneAnne may want to say something about the model statute that NACDL developed.
Right. Well, we really just followed the recommendations of the ALI, although we proposed second look after 10 years rather than 15 years. And the interesting thing here, Gabriel, is that the prisons would be charged with the obligation of notifying the courts and the individual inmate that they were eligible for the second look. So you're not dependent on families arbitrarily realizing that they had this power. And of course, the idea would be that there would be court-appointed counsel. And I was thinking of that when Judge Gleeson was talking about second looks and the lack of transparency and the opacity of the parole process. You also have a lack of representation, and representation can really make a difference. I mean, some prisoners are really able to tell their story. Their paper tells the story. It's like the resume speaks for itself. They're just amazing. But some have had issues in prison, and you often see with disciplinary issues, for example, tougher ones in the beginning, and then a readjustment, and then they may be moved to another facility, and it takes another effort to integrate their mental health issues can play a big role. And in some of our clemency cases, we're actually getting psychologists and psychiatrists to come in and evaluate them now. So there's definitely amazing work that can be done by defense counsel to flesh out that portrait of that inmate, which can be presented in court in an open way. I just want to say one other thing about second looks, that I think at the federal system, we have less violence at the federal system. We have a lot more white collar drugs. At the state system, it's over 50% violence. And I do think, and this may be sacrilege, but I kind of think sometimes the parole process can work better in a violent situation, because that's where the process will happen more quietly, and it may be easier to get buy-in from victims. That is not something I've studied, but I just wonder whether you sometimes read about people on murder cases getting out on parole, and whether that would happen as easily in an open second look process in federal court. I'm not so sure.
Great. There's a question going to, or a point being made going to the fact that folks who've been released recently because of COVID from federal prison, that it's a missed opportunity to basically see how they do to underscore the fact that prison can successfully rehabilitate people. So it's making that point that this is a blown opportunity, but it begs the question of what is the point of our system, our justice system, and incarceration. And what I learned in law school, there are three reasons: deterrence, rehabilitation, and punishment were the point of our system. And I guess I would pose to the question, the question to the group is, what do you think is the primary purpose of our justice system and incarceration specifically of those three, or is it something else?
I'm happy to talk if nobody else wants to talk. You know, they tell us, you know, deterrence. You look at 3553A2, deterrence, incapacitation, retribution, just desserts, and rehabilitation. And they're in tension with one another in any particular sentence. But you know, you could debate what our beacon should be. One of the things, however you come out, it ought to be driven by data, right? And my colleague at NYU, Rachel Barco, wrote this book, Prisoners of Politics, where that's, dovetailing with the commission's direction to the commission to keep up with advancements in human knowledge, right? And we make the world more dangerous by having prison terms that are longer than necessary to reduce recidivism. And there comes a point when the longer the term, the more likely they're going to be recidivate. So, I'm less drawn to choosing a beacon, right? Justice Breyer tells us the original commission couldn't decide on one. Then I am making sure that we pay attention to the cognitive development of young inmates. I've got clients now, we had no idea back when they were sentenced that their brain hadn't even been, they're fine, they're adults from a criminal justice perspective, but they're not adults cognitively or psychologically. Same with recidivism rates. We're terrible, just like we were terrible when the social scientists told us that our eyewitness identification stuff was all screwed up. We didn't do anything about that until the exonerations came along, and it took us 20 years after that. We're terrible systemically at adapting to advancements in knowledge. And I don't know how you get better at that, except just say it over and over again. We ought to be data-driven.
Thank you for that. Anyone, Professor Chin?
I don't think that there is any one philosophy behind the criminal justice system. And, I think it's a product of politics, sometimes for good and sometimes for ill. But people in the legislature have a lot of reasons for voting for a particular criminal law to be passed or a particular sentencing scheme. And I think some law professors spend a lot of time thinking about justifications for punishment, but I think the real answer is that everybody thinks that there should be some sort of criminal legal structure. Everybody thinks that there should be some criminal laws that are enforced in some way. But the reasons for that and the implications of that are not agreed upon. Yeah, and so it's ad hoc.
Mm-hmm. Margaret?
I just wanted to add to that. I think the beacons are fine, but I was immediately recalling a comment that Doug Berman made at a conference, 12 years ago, on second book, believe it or not. And Justice Kennedy walked in the middle of that conference, and he was carrying a book about reentry, which wasn't exactly the topic of the conference, but it was a wonderful signal of things to come. What comment Doug made was that we always hit people harder at the beginning than we intend a couple of years perhaps later. And there really does have to be a point at which you can change your mind. And that has to be institutionalized. Some states have done it. The federal government seems particularly backwards in that regard. We were sort of struggling with this notion. I think the idea of emblematic grants by the courts, individualized, individual pardon grants are fine because they show what can be done. But there really does have to be a systemic mechanism, and I think it should be through the courts, at least in the federal system, to reconsider that too hard of a hit at the beginning where we're all determined that nobody should be able to rob 17 7-Elevens down I-95 in a row in one afternoon. So there's an interesting case in the Supreme Court, actually, under the Armed Career Criminal Act, which that they're going to be hearing argument in October, called Wooden, US v. Wooden, where that's exactly what happened. Some guy in one evening, in the space of about an hour and a half, broke into 10 storage lockers. They were all inside the same building. And he now was charged with 10 separate crimes. There's just got to be a way that we can have a second look, or in the case of people out of prison, second chances.
JaneAnne, speaking of second look, in your state, there have been efforts to use the courts to do just what Margaret talked about, offer a second look to juveniles. And most folks generally have a softer view when it comes to kids and their ability to grow and change and mature as life goes on. But my understanding is that you have encountered, or those efforts to ask for that second look from the courts in relation to juveniles has met stiff resistance. And I'm just wondering if you could talk about that and where the resistance is coming from.
Actually, you may have that may have been a miscommunication, because I don't. There's another professor at the law school here who works on juvenile justice issues. I believe that there were various limitations statutorily to some of the reductions. So I can't say that there is a big opening here in Minnesota for juveniles. And as I mentioned earlier, the statute to give a second look for juveniles or previous juvenile offenders, second look at 15 years, failed in the legislature.
Right.
But there is an effort to now do a conviction review unit that's run by our Attorney General, Keith Ellison. And there is some buy-in, I understand, from prosecutors across the state. And so there is a movement towards that. We'll see how it really pans out. It's just started. There was an effort recently to, through the courts, to fix the clemency process here, which has been subject to a unanimity vote. Unfortunately, the Supreme Court of Minnesota ruled that challenge out. So we're stuck with a clemency process that requires a unanimous vote between a Supreme Court justice and the Attorney General and the governor. And as such, it has been unable really to grant any commutations. So look, these things are multivariate. There's public will, there's prosecutorial will, there has to be legislative will, there is a mobilizing of various different forces. I was just struck by something Judge Gleeson said there about us being data-driven. You know, we all love data when it works well for us, and then when it doesn't work, we want individualized justice. And I think in many ways we need both. We need our data to analyze what's going on systematically, but we also, at the end of the day, want our people in prison to be treated as individuals, and that there be some kind of individualized humanistic approach to assessing their situation. So that's not really answering anybody's question, but just bringing in the level of problems and issues we face going forward.
Right. But your mention of the law that did not make it past the legislature does seem to indicate that they're with kids, which again, many would think would be the easiest folks to say we need to do a second look with them, but that didn't get through. And so that's interesting that there was resistance even to that.
Right. And I guess that it comes down to individual politicians not wanting to have that sort of on their watch. And why the process that Judge Gleeson, for example, is pursuing with the Holloway project is that we do need to mobilize our courts in this process, where there is a second look built-in legislative remedy right there in the First Step Act, which courts can seize if they choose, rather than waiting for legislatures who will always be looking at the next election and the negative ad that they're going to face for their vote.
And speaking of worrying about future consequences, Judge Martin and Judge Gleeson, what is the perspective of judges who could grant second looks and then potentially worry about what folks will do if they if they actually get the second look and are released back into the community? It's different from an elected official who's worrying about the next election, but what is that fear that the judges face?
I don't know. I don't get it. I mean, I think that's why we have lifetime tenure, right? Because, we're supposed to make the tough decisions, and we're shielded, if things don't turn out the way they're, we hope they will. If I can just, I know we're running short on time, but I had a recent experience, the opposite of data driven, that I just wanted to, kind of bring back my point that the people that we've sentenced as judges, I mean, those are our people. And when we leave this earth, they're evidence of our life's work. And I think we continue to be responsible for them. I have a nephew that here is in college here at Georgia Tech, and he had a birthday, and I took him out to dinner down near where the Braves used to play when they were a downtown baseball team instead of a suburban baseball team. And it's kind of desolate down there. And so we had finished dinner, and he said, let's go walk. Well, there wasn't really much place to walk. It was kind of dark. And when I was walking back, of course, we're wearing masks. So walking back, and I hear this person on the street who's just miserable. He's hungry, he's dirty, he mentioned, I could hear him say, that he had been in prison. And as God is my witness, so I have a mask. I turn around, I hand him a bill, and he looked at me and he went, "You're the judge. You're the judge." And of course, my nephew started to panic. It's like, oh, what's going to happen here? And so I stood there for a minute and had this, it's very emotional. I had this, very compelling conversation with this young man. And I wasn't sure if he really knew who I was. But he told me his name, and, we talked a minute about, what had happened to him in my courtroom. And I think I came, and I told him that I wished him well, and that I hoped he could put that time in prison behind him, and that he could succeed, and what possibilities might await him. And it was just a really kind of a lovely moment, for him and for me. Maybe not my nephew, but and so I came back and I looked through CMECF, and I think I figured out he really had recognized me even with the mask on. So I'm in the part of my life where I've recently experienced the death of my parents, and so when you think about what is our life going to stand for when we leave this earth, I think those people that we came in contact with as judges are part of our legacy. It's our responsibility to find a way to help them if there's any way to do that. And I don't know that was exactly responsive to your question, but I really think that's true for all of us. And of course, we were given lifetime tenure to help us play that role.
Mm-hmm. Well, unfortunately, it's a powerful story to end on. And I think we're just out of time, but that kind of encapsulates the collateral consequences that go along with a criminal conviction that can help push somebody into a situation like it sounds like he was in, and the lack of the ability for the courts or others to do a second look to help folks like him. That just brings that all to light. So thank you for that story. We're just about at time. Doug, I see you back. I don't know if you want to make any closing statements or anything.
I just really want to thank everybody. Thank my technology servers for getting me back online, and so I can not only express my gratefulness to you, Carter, for moderating this terrific discussion, but to all of our panelists for sharing their afternoon and all these incredible insights. There's so much here to talk about. Wonderfully, we have one more opportunity, although that's going to be focused particularly on the federal pardon process and whether or not the Department of Justice should still play the central role that they've been playing through the years. And I hope all of you who were able to join us today and many more will come along for that ride. And one more time, just a special thanks to Margaret Love for helping to put all this stuff together and to enable us to keep talking about such critically important topics for conversation. And attendees, thanks for stopping by, and please come back next week. Thank you all. Appreciate it, and take care.